a privilege to be here and to be here for the Finnegan Freedom of Information Award. I had the honor in a past life of working with Joe Finnegan at the Ryder Bennett firm, and I'm really happy to be able to be here for the John Finnegan Award and its presentation. I'm also happy to be here to talk to this group in getting ready for the speech. I spent some time looking at your mission statement and your statement of guiding principles, and one really caught my eye. It says, government at all levels has a responsibility to promote public participation by support of open access to all public government information. You know, I really couldn't agree with that more. Courts derive a significant part of their authority from the fact that people trust them, that we have a high level of public trust and confidence in the judicial system is in no small part related to the fact that in Minnesota courts are pretty open. You know, if you were interested at all in the oral arguments in the allotment case yesterday, you didn't have to be in the courtroom to hear them. You could have been elsewhere in the Judicial Center for a closed circuit television feed. You could hear them over public radio. You could watch them on a webcast. And today you can go back and you can replay them as much as you want off the court's website. You know, it's when I was an appellate advocate, I used to like to go back and watch my arguments, because when you're giving the argument, you kind of really forget what you're asked and what you say. It's kind of, you know, there's the speech you plan to give, there's the speech you gave, and there's the one afterwards that you either thought you gave or wish you'd given. And so I think that that's just a really good example of the openness that Minnesota courts have. And it isn't just the arguments, you know, it isn't just that case. We do that for every case. Now, we don't often have you know, live feeds coming out of the courtroom, but we have them available out of the Supreme Court for every case that we hear, whether it's a lawyer discipline case all the way up to something as significant as Coleman Franklin. Courts have to operate in the public eye. They deserve to have their actions scrutinized. And we expect a report in mid-April from the pilot project on cameras in the courtroom. Now, it's interesting. I've been described as someone who actively supports cameras in the courtroom. What I did was sign an order that says we're going to look into it more. So I don't want people to get too far ahead of themselves on that issue. Televising appellate arguments is one thing. You have trained advocates and you have judges who are focused on the process of communication. When you start televising things that happen in the courtroom, you have lots of people who don't want to be there, lots of people who are being asked to discuss very private and personal things, and people who are frankly downright scared. If you read the report of the advisory committee, there was significant concern expressed by people who work in the system day in and day out about the chilling impact that cameras in the courtroom would have on the ability of those victims and those defendants to fully participate in the process. What the Supreme Court did in the order that I signed was to ask for some empirical information, to ask to have a study set up so that instead of people's impressions, we could actually have some hard data, if it's possible to get it, to see if those fears were real and whether they were real enough to outweigh the unquestioned importance of public access in the courtroom. We expect to receive a report from the committee outlining the pilot project in the middle of next month, and I think that we'll go forward, but we will go forward thoughtfully and in an effort to balance all the interests that are being presented. Hopefully we can get some empirical information to help us make a better decision. Now, it isn't just access to the courts through watching the arguments or watching the proceedings that's important, although that is very important. In Minnesota, I think we are a leader in making our court records available to the public. You can get information on most any case in the appellate courts just by going on our website. You can't get the briefs because it just costs too much money for us to reproduce them all, but you can get them if you really need them. And that is simply another example of the dedication of our justice system to being open and to being accessible. We have our own branch rules on public access that presume accessibility, and I think that those stand us in good stead. In addition to that, what the court system has tried to do is make itself actively available to the public, not just references, but resources. We have a virtual self-help center that is a significant aid to people who need to be in court, don't want to be in court, need to be in court. They're there because they have to be, but they can't afford a lawyer. So we try to give them as much help as we can. Not for them so much, although that's important, but for the courts. Courts don't function well if you have people who don't know what they're doing in it. That's been one of my themes as I've talked across the state on adequate court funding, adequate justice system funding is what I've been calling it. Because if you don't have adequate system funding, if you don't have adequate funding for the public defenders and the prosecutors and civil legal services, the judges can't get their job done. So we find the more we can help educate pro se litigants, we do that through our information systems on the court, the better off that we are. I can talk a little bit about my personal experience. You know, I was an advocate for 30 years, and I have to say when I argued a couple cases that had some fairly high public interest and cameras were in the courtroom, I never noticed. You know, those cameras are in there, they're embedded in the walls now, and even when you get folks like these guys with the tripods, you know, they're behind you. You don't really notice it. I do remember once I argued a case in the Minnesota Supreme Court. It was the first, one of the early cases when the court had a majority of women, and it was a sexual assault in the workplace case, so you know it had all sorts of interest. And the New York Times sent somebody out to cover it, and they did a big story on it. And just to show you the impact the media has, I got a phone call from my mother who lived in Hayward, Wisconsin, the day after the argument. She says, "You're in the New York Times." I said, "Really?" She said, "Yeah, look at page such and so," and I did. And I'm on the phone with her and I look at it and I say, "Well, Mom, that's the back of my head." And she says, "A mother knows." But cameras in the courtroom, at least at the appellate level, in my experience, just really don't have much impact. You know, we've got them, as I said, embedded in the walls. We really don't pay too much attention to them. But it is nice, for example, if you're unable to participate in a case as a justice because you know you're off giving a speech somewhere, or you get snowed in. That happened to Russ Anderson more than once. You can yourself participate in the case, even though you weren't there, because you can watch the oral argument and hear it. And I think that that's really, really important. I think that on a broader level, access to government in other areas encourages public trust and confidence. And I'll speak a little bit about my own personal experience on the canvassing board. For those of you who haven't heard this story, I'll tell you how I got on the canvassing board. I was in office a couple of months and I got a call from the Secretary of State's office, and they said, well, there's going to be a general election this fall and we need to establish the canvassing board. Who from your court will be on it? Now, I've been on the job long enough to know not to answer questions like that because I had no idea what I was being asked. So I hung up and I turned to my assistant and I said, "Barb, the canvassing board, what's that?" She said, "Oh, it's in the Constitution." I said, "Really, what does it say?" It says, well, it has to be 2 trial court judges and 2 Supreme Court justices and the Secretary of State. I said, "Oh, how do I pick them?" She says, "Well, you just ask for volunteers," and you know, she said, "It's no big deal." You just go over there and, you know, you get some reports, about 15 minutes, you sign some forms, you're done, you come back, you know, you won't even miss lunch. I said, "Well, okay, should I do that?" She says, "Well, you can if you want." So I signed up, I asked for volunteers, I got Justice Barry Anderson. Who knew? Who would have thought? So when I'm watching the election the night before, I'm saying, well, this is really pretty close. I wonder when it will start to not be close. And I stayed up, and the later I stayed up, and the less close or less far apart it got, the more I thought vaguely, I wonder if I'll have to do something. Well, I did. And it was, to me, a fascinating process. You know, judges deliberate in confidence. When the Supreme Court hears arguments, we go into the conference room, and after an argument, we talk about how we should decide the case. Everybody gets to state their views, and it's frank, and it's open, and it is completely confidential. When you're on the canvassing board, everything you do is out in the open. We would get together in the Secretary of State Ritchie's office every time before we went someplace, not to talk about what we were going to do when we got there, but to talk about the schedule and what kind of cookies we would have at the break. We were fastidious in our determination to not talk about anything of substance unless we were in the public eye. Now, for someone who's, you know, even at that time fairly limited experience, but still my experience was that you deliberate in confidence. To have to do all of those things out in the open was, I don't want to say unsettling, but you know, it just required you to be kind of careful and thoughtful, and I had no idea how it was going to work. And the way it did work, in my mind, was spectacularly well. We didn't agree on everything that was voted on. Somebody kept some statistics of it, and I think the vast majority of our decisions on ballots were unanimous. We had some pretty clear statutory criteria that we were supposed to apply in discerning the voter's intent. We developed some kind of personal positions on certain things as to whether we would decide something was an overvote, an undervote, or intent was unclear. I even kept, I think I have it here. I hope I do. Yeah, maybe I can't find it right offhand. But I kept what we called the hieroglyphic sheet. You might have seen some reference to that. Oh, maybe my secretary took it. She doesn't let me lose things. It was a handwritten chart that showed that when we had an oval partly filled in and an oval with a pencil mark in it, what did we do with that? If we had an oval with an X through it, what did we do with that? If we had an X through it with initials next to it, what did we do with that? Because we needed to have some consistent rationale on how we were dealing with these. The initials is a good example. The statute says that a ballot is invalid if it contains an identifying mark. So the question then was, were the initials there for purposes of identifying the ballot, or were they there to, like, you'd initial the change in an agreement? And we decided, I think fairly unanimously, but fairly consistently, that if someone X'd out a vote and put their initials next to it, we would not call that an identifying mark. Now, you could quarrel with that, but at least we had a record of what we did so that we could do it consistently. I think the process of having the canvassing board deliberate and discuss in the open was one of the keys to whatever acceptance that decision received from the public. It is simply not a process that would have survived if it had been done in closed session and in camera, as we call it, which means no cameras. The result was subject to enough criticism on many other levels, not just what we did, but the whole process, that it really was important to have it open and above board. That transferred to the court challenge when they had the trial in front of the three judges. They decided to have that open. Again, you have professional advocates, you have not personal information that's being disseminated, and the process worked pretty well. That went all the way through the appeal in the Supreme Court. Now, as I said, court proceedings aren't completely open because you have to balance privacy concerns against the need of the public to know. One of the big cases that I argued in my career, and this goes back a ways, some of you may not remember, but it was called In-Ray Galaxy Airline, where it was Minneapolis Star and Tribune versus Schumacher. There was a charter flight, Galaxy Airlines, that crashed on its way, I think, to Las Vegas, and a number of Minnesota residents died. The cases were consolidated, and then they started to settle. And in many circumstances, the settlements required court approval. For example, the distribution plan in a wrongful death case, you had to get court approval, not of the settlement, but of the manner of distribution of the proceeds. And the lawyers for the parties decided that they wanted the substance of those settlements to be confidential. And the media thought that the public needed to know. And I represented the collective plaintiffs in the case on an appeal to keep that information confidential. And this is just a little example of why you need to do something like that. When hearings were held to approve certain settlements, you would find that on more than one occasion, the home of the person who's got to be in court was burglarized because people knew they wouldn't be there. They were victimized by predators trying to get some of the money. And the more publicity you had, the more at risk those people were. Now, in the end, was the right balance drawn? I don't know. You know, so much of the decisions that we make and things like this are gray and unclear. But it is, I think in the end, the most important thing is to have the discussion. And so this gets me a long segue back to cameras in the courtroom. We're going to continue to have that discussion. We're going to get the report from the task force. We're going to figure out how to study the issue so that we ensure that we protect both the right of the public to access to their courts, which is extremely important, and the right of private citizens to keep those things private that should be private. I'm really looking forward to it. I want to participate in that dialogue as long as I can. I'm not sure that I'll be quiet after I'm done being Chief Justice, but maybe then I'll only want to listen to me. So with that, I think I'm open for questions. Sir.
Yes, Chief Justice Magnuson. First of all, just as a citizen and an observer of the process and all that, I'm sorry to see that our state is losing someone as good and as open and scholarly, to who I think could bring a lot to the justice system of Minnesota, and hopefully after June you'll still be involved in the process and still let your points be known.
Yes.
So once again, I just say thank you for your service. And I'm just sorry from my own side. Secondly, with the question, I'm someone who interacts with the judicial system all the time. And one of the things I've noticed, when we talk about openness and access and access is a broad term. It's where I like to take documents home and read them on my own time. But there's a high cost for 2-page, 3-page, 4-page documents. There's a judges meeting in Ramsey County that I've been trying to go ever since Judge Fleming was the chief judge there. We're talking about 25 years to see the administration of justice. And that's what the term in the statute says. I want to go to the meeting. They meet once a month. I'm sorry, but it's not an open meeting. And then one of the other things recently which happened in Hennepin County, as you may know, there are a number of employees under suspicion of doing something wrong within Hennepin County. They were state employees. Under the rules, which I saw Justice Simonette be developed and all that, so I've seen them develop over the years. I knew what the rules were. I wanted to know the existence and status of employees and their charges. And I was told by the clerk of court at that time, you're not going to get those. So I seek openness in with the cameras and all that's important, but sometimes with the underneath type of stuff where you need the information, and for citizens to make sure that courts are accountable, you don't get all that sort of stuff. So I just wanted, if you could just share your insight to some of those points that I bring up.
Access to the courts by anyone who wants information is incredibly important. It is a balance, however, just how much information you give without intruding on people's privacy. If you're familiar with the federal courts and their electronic filing in civil litigation, for example, there's a requirement that you redact certain private information, social security numbers and things like that. We're starting a pilot project right now in Hennepin County that we expect will go pretty quickly for electronic filing in civil, and then we'll move it to criminal cases as well. When we get the documents online in electronic format, it's going to be a lot easier for you to get at them. It's not something that we can do all at once. We have to do it as part of the process. You know, I think that we're going to continue to make progress in those areas.
Yeah.
Sir. This will be the last question.
When you share your thoughts with us about the proposals we have to change the election of judges.
The question is, what do I think about the proposal to amend the Constitution and provide for retention rather than contested elections? I think it's absolutely vital. I think that, as I said, courts function because people have confidence in them. And if there's anything that came out of the decision of the United States Supreme Court in Caperton versus West Virginia, that's the big campaign contribution to the Chief Justice who did not recuse himself. It's that people do not believe that judges can be fair and honest when there are big campaign contributions. If you go to retention elections, you take the incentive to give big campaign contributions either for or against a judge completely out of it. You get judges that not only are selected on merit, but when they stand for re-election, the electorate actually gets a report card on the judge from a disinterested group. And to me, the answer is simple. When you go and vote for judges and you turn that ballot over, because they're always on the back side, and you look at the 20 judges you're expected to vote for, do you have the slightest idea who you're voting for and whether they're good or bad? You don't, but under the proposal, you get an evaluation, and they will come either recommended, highly recommended, or not recommended. And that's going to mean voters get the choice. Thank you.
Thank you so much.